Tout le monde, bon matin.
Welcome everyone, good morning. I hope that you've had the last few pleasant days in Ottawa. Welcome to meeting number 125 of the Standing Committee on Procedure and House Affairs. Today, we will be continuing our study of Bill 377, an act to amend the Parliament of Canada Act, Need to Know.
To witnesses and colleagues, make sure that your earpiece, when not in use, is placed on the sticker in front of you to protect the safety and well-being of our translators who work so hard on our behalf. Aujourd'hui, avec nous, today with us, we have two witnesses. So welcome to Michel Bédard, who is the légiste et conseillère parlementaire. And welcome to Marie-Sophie Gauthier, the Senior Legal Counsel and Team Leader for Legal Services. So, Monsieur Bédard, I'm not sure if you intend to split your time or if you'll be speaking on your own, but we'll give you the 5 minutes to use, and then we'll go into our regular line of questioning. Once we hit the hour, we will suspend briefly in order to transition over to our second hour. So, it looks like we're ready to go. Avec ça, Monsieur Bédard.
Without further ado, Mr. Bédard, you have the floor. Mr. Chair, members of the committee, thank you for your invitation to appear today regarding Bill C-377, an act to amend the Parliament of Canada Act, Need to Know, which has been referred to the committee after second reading in the House. As you said, Chair, I am joined here today by Marie-Sophie Gauthier, Senior Legal Counsel and Acting Team Leader. We trust that our testimony today will assist the committee in its examination of this legislative proposal.
Provide legal services and legislative drafting services to the House of Commons, its committees, members of Parliament, the Board of Internal Economy, and the House Administration. Our legislative drafting services include the drafting of private members' bills, such as Bill C-377, and motions in amendment at committee and report stages. Our drafting legislative services are provided confidentially to members of Parliament, and the information I will provide today to the committee will factor in these expectations as regard to my office. Bill C-377 proposes to amend the Parliament of Canada Act so that members of Parliament and senators who apply for a secret security clearance from the Government of Canada are, for the purpose of the consideration of their application, deemed to need access to the information in respect of which the application is made. Access to information of the Government of Canada that is either protected or classified is a two-step process. First, there must be a need or justification to initiate the security screening process, which will result in the individual receiving a reliability status for protected information or a security clearance for classified information. Such a need or justification is traditionally identified by a government department or agency. Second, there is the need to know principle, which restricts access to sensitive information to those whose duties and functions necessitate access to the information. A person is not entitled to access information classified at a certain level merely because they have the appropriate level of classification or clearance. They need to know the information as part of their functions, regardless of their clearance. I note that the unauthorized releasing of classified information may lead to legal consequences, such as prosecution under the Security of Information Act. L'accès à des informations protégées ou
Access to protected or classified information on a need-to-know basis by individuals holding the appropriate level of clearance must be distinguished from the House of Commons parliamentary privilege to send for persons and records. This power, generally exercised by committees, supports the role of the House as the grand inquest of the nation and is essential to the proper exercise of the House's right to institute and conduct inquiries. The power to send for persons and records would be unaffected by Bill C-377. Moreover, new proposed subsection 3.12 of the Parliament of Canada Act would make this unambiguously clear by stating that the proposal is not to be construed as limiting in any way the powers, privileges, rights, and immunities of both houses of parliaments and their members. The privilege of freedom of speech would also be untouched by Bill C-377. Members speaking in the House and committees would continue to benefit from a criminal and civil immunity for their words spoken as part of parliamentary proceedings. That said, this immunity does not apply outside of parliamentary proceedings, and members of Parliament would be, as other citizens, amenable before courts of law for words spoken or communication outside the House and committees. This concludes my opening remarks, and we'd be happy to answer any questions you may have.
Merci beaucoup.
Thank you very much, Mr. Bedard.
For 6 minutes.
Thanks, Chair, and thanks for coming today. Look, I think you highlighted very clearly, what my bill is trying to achieve here, and the challenges, not the challenges, but why it's so important. A couple quick questions to just sort of highlight that first step of having parliamentarians needing to have access. Can you refer or aware of historical examples where Parliament has asked to see classified or secret level documents?
Thank you for the question. I think that in your speech in the House of Commons and before the committee, you refer yourself to some examples. There is, of course, the Winnipeg Lab documents precedent that was a few years ago, which led to a ruling from the Speaker, and eventually there was an agreement reached by the government and the opposition as to how the documents will be made accessible to members of Parliament. And as part of this process, an ad hoc panel of parliamentarians was created, and one of the conditions was that they get a security clearance. This precedent was inspired by another president from the previous government in 2009, 2010, the Afghan detainee documents. Similarly, there was an order production, there was some resistance and dialogue between the opposition and the government, and the same deal was struck between the government and the opposition.
And was there any, I guess since that, has there been any concerns flagged by the House of Commons, by Parliament, on leaking of any information now that the Parliament had more members with a secret security clearance outside just government?
I'm not aware of any concern that were expressed. The two precedents that I referred to, there were a limited number of members that received the classified documents. Since then, there are also other precedents. The Johnston report was, and related information was made available to some members that had agreed to receive security clearance, and the government had agreed to provide it to them, provided that they go through the process.
Specifically, so on to another subject, foreign interference has been very prevalent, and this desire for parliamentarians that have flagged, to the government, to the House, as well, of the need to get greater levels of detail and information, especially when there's threats to them. Do you have, in your opinion, would it be valuable to have these members to a higher security clearance so they can properly have that information and that intelligence that is, potentially putting them at risk?
I think that in such a case, what is important is that members be made aware and that they have the relevant information so that they can take the appropriate measures to protect themselves. Now, whether the information that is required to be provided to achieve that objective, I think that will be on a case-by-case basis. And if there's a need to share classified information to members so that they can protect their security, I think that it's a genuine need and it should be addressed.
To sort of go back to the historical examples, can you speak to your involvement or your office's involvement that should this bill pass and the clearances be granted that you would play in that role? And how long does this take? Because I think some of the issues when we look at the historical examples where ultimately a decision was made, it takes time to actually get a security clearance and do that proper vetting process, and should you be successful. And that does take times within just, delays the sort of necessary accountability and transparency. I don't want to say transparency from, in the public view, but from a transparency of Parliament to actually do their job.
I think it is important to underline that the government security process, the screening process, the House of Commons is not involved. It's really a process that is led by the government, and once a person has demonstrated that as part of his or her function need access to classified information and can go through the screening process and receive the clearance, then there is the second step, the need to know as to specific information. So the custodian of the information that is classified will assess whether or not this person need to know the information. So it's a process that belongs to the government. Our office will not, and the House administration will not be involved in that process.
My final question is do you have any suggestions for amendments? There's some of the concerns that have been raised during the appearance and my testimony even on Tuesday was, some confusion around the two-step process and understanding that my bill is only about allowing parliamentarians the right to apply. Do you have a suggestion maybe how there could be an amendment that would make that clear?
Thank you. Thank you very much for the question. And this is indeed something that I noted when I was reviewing the bill as I was preparing to this appearance. As I mentioned, access to classified information is a two-step process. And you were very clear in the House and before this committee that you want to address the first step of the process so that members of Parliament be deemed as part of their function to require from time to time access to classified information. And then the second step of the process is the need to know, which is on a case-by-case basis. I think that's some confusion or there might be some ambiguity around the bill because while you're addressing the first step of the process, the need to know, it's really terminology that is used for the second step of the process. So if there's a will to address this ambiguity, or if the committee feels that there's an ambiguity, we'll be pleased to assist the committee in preparing the appropriate motions and amendment.
Thank you very much, Mr. Ruff. Madame Fortier, the floor is yours for 6 minutes.
Thank you, Chair. Thank you for being with us here today. I think that your expertise will allow us to have a better understanding of your interpretation of the private member's bill, as well as the impact that this bill may have if adopted as written. My questions will pertain to your expertise and experience. Also, if you have suggestions for clarifications for committee members, that's always something that we can take into account. I have a question about parliamentary privilege. What can you tell us about how parliamentary privilege applies with regard to the right to information? Do parliamentarians have an inherent right to information? When we speak about parliamentary privilege, and I said so in my opening remarks, parliamentarians have the right to ask witnesses to appear and to basically to send for persons and documents. Parliament, House of Commons, the committee has a right to documents. The committee needs to make a decision on this matter, or the House needs to make a decision. A parliamentarian individually does not have the right to exercise that privilege. It does require a decision from the House or committee to exercise that privilege. And is there an impact on this with how the bill is currently written? Bill C-377 would set out that members who would ask for security clearance would be eligible for the procedure. There's a safeguard for privilege caked into the bill to ensure that there is no new privileges created or any breaches of privilege, parliamentarians would not have additional access to information. They would simply have access potentially to a level of clearance so that they could receive information from the government. This is information that belongs to the government, and it's up to the government to decide whether they will share the information with the Member of Parliament. And do you think that there are already mechanisms in place that would give parliamentarians the same levels of access as is proposed in this bill? We have discussed precedent before. There have been ad hoc committees, for instance. They were created to grant access to certain types of information. One of the conditions for documents made available was that members of Parliament have a security clearance. The same applied when we were speaking about foreign interference. If the members affected by foreign interference had the appropriate security clearance, the government, if it had that information, could share that information. And which organization would be in charge of screening MPs and determining level of clearance with this bill? This is the government's affair. The House of Commons does not play a role in this regard. When it comes to security clearance, we speak with the Privy Council office and we speak with CSIS, depending on what procedure is at play. According to you, after having that level of clearance, how would parliamentarians access this information? Would it be paper copies in a secure environment? Would it be a digitally secure document? Do you have any ideas of how we could manage the transfer of information and how parliamentarians can use this clearance? It is the government's information. It is the government's security clearance level. It is, again, the government's practices and standards that apply here. If we talk about top secret information, there are measures that are very strict. You have to go into a room. You have no access to your cell phone. But with the same procedures that are already in place, would you have any other suggestions for if and when parliamentarians get this new level of clearance? The government's practices would apply. It's imperative to understand that the bill does not address the privilege of parliamentarians. It's really about the level of information that belongs to the government. Thank you. Thank you, Ms. Fortier. Ms. Gaudreau, you have the floor for 6 minutes. Mr. Chair, it's almost as if we spoke about this in advance because you've really set the table here. I hear you said government procedures a number of times. You know, in the last meeting, we heard about the structure of a parliamentary committee. You said that it is indeed a mission of government and not of parliament. These committees sit for the government. Isn't that the case? Often there's a confusion about the Committee of Parliamentarians, or when we're talking about either NSICOP. There is a terminological issue here with a parliamentary committee versus Committee of Parliamentarians. So it's a statutory committee created by statute. Yes, it is made up of parliamentarians, but it operates in an extra parliamentary context. Parliamentarians on that committee need to have the appropriate level of clearance. There's also a mention of parliamentary privilege in the bill. Parliamentarians receiving some information as part of their work could not then disclose that information in the House because there is a line in the bill saying that parliamentary privilege is not affected. The bill seems to highlight a dichotomy between privilege and the work of Parliament versus national security. We also heard that there were other organizations where this does not fall under a government procedure, where it comes from the leaders group. Do you know any other parliaments or legislatures in the Five Eyes, for instance, that have a structure that doesn't relate to a government procedure, or versus that would be a better off for the needs of that parliament? Every parliament has its own needs, and the government plays a various role depending on which jurisdiction is at play. I haven't looked at other jurisdictions. I believe that PROC should review how the Committee of Parliamentarians works in order to meet the needs of the right to know, the need to know, the privilege, and all these other elements, in addition to what we do with the information that we receive. This is to ensure that when we ask for information, we receive it in order to carry out our responsibilities dutifully. If we place a larger emphasis on governance and the proper operation of a committee of parliamentarians, could that be a potential solution instead of adopting Bill C-377 as written? Thank you for the question. I think it highlights a more global issue than what we are studying today, that is the overall relationship between parliamentarians and the government when it comes to access to information. Mr. Ruff's bill speaks to a very specific policy that would allow members wishing to gain access to the security screening process to have that, to try for that clearance. It wouldn't automatically grant them that access. If the bill is adopted, I would trust that there's a certain governance structure that will be in place, and the parties will have various responsibilities with regard to what level of clearance is sought, what happens when a clearance is refused. I believe that the political parties would enter into talks afterwards. Chair, to close off with, what I would just say is that what we have currently as options is that we use our parliamentary privilege via questions of privilege to gain information that we should be getting for the well-being of our democracy, instead of needing a level of security clearance. You know, who am I to ask for information that I don't know what to do with? And how would this information be useful when there is a very specific way to get that information? All members of the Committee of Parliamentarians receive the information that the government offers to them. So what could the committee do with that information? It would have to be PROC or the House that orders the disclosure of documents. The Committee of Parliamentarians exists in parallel with Parliament. There are certain statutory rights to information, but members who are part of the committee, and I say members of the House and the Senate, they are bound by their level of security clearance and bound to respect the various legislation and bound to their parliamentary privilege. Parliamentary privilege does not apply. That means that a member of the committee could not rise in the House to disclose information. Thank you. My time is up, but I have further questions later. Thank you, Ms. Gaudreau.
The floor is yours for 6 minutes.
So I appreciate you coming today, and just to continue on that conversation around privilege. So you had just mentioned that there's almost a forfeiture of privilege, parliamentary privilege, when those members of NSICOP become members, but that has more to do, I think, because they certainly have a higher level of security clearance than we're talking about with this bill. However, it's specifically not in this bill of that forfeiture of privilege. Do you see any problems with that in terms of, per se, like if a member were to breach that, they release documents because of that classification or whatever, what are the ramifications? I mean, they're still protected by privilege. So what are the ramifications on that?
First, you're correct that in the legislative proposal, there's no exception that is created for parliamentary privilege. So if a member of parliament were to receive classified information and then disclose this information in parliamentary proceedings, there could be no prosecution under the Security of Information Act. Parliamentary privilege will protect the member, and this has been established. There are precedents in the UK, and is the state of the law as it stands. And that's why that for the NSICOP committee, there was a quid pro quo in that they were to make available more information to some members of parliament, provided they essentially forfeit their parliamentary privilege, and they go through the screening process and get the proper clearance. So it's a policy decision ultimately. There is always the need to know principle that is applicable, so that it's the government that will decide what information it will share with members of parliament. So if this bill is adopted, there is information that is disclosed as part of parliamentary proceedings, regardless of the clearance that some members of parliament have. The government could decide to simply stop sharing any classified information with members of parliament.
So whether that breach was done unintentionally or intentionally, I mean, this doesn't really change what the government can allow out or not. This doesn't change any of that. It doesn't have any furtherance in terms of transparency that I think this bill is trying to accomplish.
There have been some precedent, or there might be scenarios where, as part of their parliamentary functions, there is a need to share classified government information, and in those cases, the members of parliament receiving the information had to go through the process before receiving the information. Now, if there are within each caucus certain members that have already been cleared, or because of their particular position or role on specific committees, or maybe they're more subject to foreign interference, if some members have security clearance, then if there's a need to know, the government could share this information with those members without having them first go through the process again, because they will already have the clearance.
With this, it would be incumbent upon the member themselves, whether or not they choose to get that security clearance or not. Is there a possibility, so I'm thinking about the situation, we discussed this a little bit in the last committee about if you're on a committee, I'm on the National Defense Committee, and so one would assume that I might need further clearances if I'm allowed them. However, if I've chosen not to do that, does that automatically impede the rest of the committee? Does that create, that certainly creates difficulties within, I think, the parties to decide who sits on those committees, but is there a consideration of that in terms of how committees continue to function, who gets to sub into committees, the rights of a parliamentarian to sit in, even though they're not a sitting member of that committee, if they want to sit in and they don't have a clearance and there's a discussion, do they have the right to then sit in? How does that work?
The clearance that we're talking about in the bill is really about the government. It's not about committees. So when a committee is requesting information from the government, whether its members have clearance or the level of the clearance, it's no longer relevant. The committee and the House of Commons are entitled to the documents that they request.
Would this, so as a member and in terms of the privilege I have, a lot of the parliamentary privilege I have expands to the operations of my office. Staff are covered under that to some degree, in terms of the business that they do under my name in my office. So in terms of this clearance, is there a potential expansion on that in terms of the staff? Because I know in terms of, and again, it's different, and I understand in terms of NSCOP, there's a higher clearance level. However, they have exempt staff as part of the operations that they must do. Would this then apply to our staff, or would we have to go through all of those applications for our staff? How would that all work? Sorry.
So the bill is very specific to members of parliament and does not include member staff. And if you receive information, if this bill goes through and eventually you receive information, top secret information, for example, you wouldn't be allowed to share it with your staff.
Thank
continue
you
on
very
with
much,
that.
Ms. Matheson. Mr. Cooper, the floor is yours for 5 minutes.
Thank you very much, Mr. Chair. Mr. Bedard, you referenced two precedents in which members of Parliament who were appointed to special committees were granted security clearances, the first being with respect to the Afghan detainee documents, and the second and more recent example being the national security breach at the Winnipeg lab. In both instances, is it correct that members did not waive privilege upon being granted those security clearances?
This is correct.
And so that's distinct from NSCOP.
That's correct.
And so we have two examples. Are you aware of any instance in which a member of those two select committees used their privilege to publicize what otherwise would be classified information?
In reference to those two...
In reference to those two committees in which
no.
those members did not waive
I'm
privilege?
not aware of any incident.
Right. And I think it goes without saying that if a member of Parliament did in some extraordinary circumstance do so, there would be repercussions, including political repercussions for doing so if they in any way breach national security or other issues. But we have two examples, and I find it passing strange that there are 250,000 people that have been granted a secret security clearance, but members of Parliament seem to not trust members of Parliament to be granted access to such clearance. But 250,000 people, including every ministerial staffer, has such a clearance. Now, going to the language of the bill, there was a question about perhaps an ambiguity. You noted that there were two steps to obtain a security clearance, but not to obtain a security clearance, but two steps to receiving information that is classified as secret, and that is first to get oneself in the door for the purpose of applying and being granted a clearance, and then the second step would be actually getting information that is protected as secret, which is at the disposal of the government in terms of making the determination as to whether that person who has the clearance is granted access. For the purpose of applying for a clearance, to get through that first step, one must have some need to know, correct?
I will say that generally it is correct.
Yes.
But in the intelligence or information world, the need to know principle or terminology is used in the second step of the process. So that's why I was referring earlier to some confusion.
But at both stages, there's a need to know. There's a need to know to get one's foot in the door. I mean, not anyone on the street could just apply for a secret security clearance by virtue of being a ministerial staffer, by virtue of being a minister, by virtue of being an officer in the Canadian Armed Forces. Those would be bases upon which there would be, at the outset, a need to know. But then, when it comes to the information that someone might obtain, that would be a whole second analysis done as to whether they needed to know that particular information that was classified, correct?
That's generally correct.
That's generally correct.
But if I may add,
Yes.
Clarify, the need to know principle or test will apply in relation to specific information in the two-step process that described earlier.
Yeah, but if you look at the language in the bill, it says for the purposes of the consideration of their application and of which the application is made. So it's very, very clear that it's in reference to the application.
There are different ways to say the same thing. I think that the intention behind the bill is very clear, and Mr. Ruff, in his speech before the committee and in his speech in the chamber, made it very clear. Now, I understand, and there was a question asked along this line that there could be some questions raised about the language. I'm just saying that if the committee feels that it should be clarified, then my office is available to prepare the appropriate motion and amendment.
Thank you very much, Mr. Cooper. Mr. Turnbull, the floor is yours for 5 minutes.
Thank you, Mr. Bedard. So currently, well, you've said here today that there are some statutory rights to information that MPs have, but I think you've also said that MPs do not have a right to classified information, right? Otherwise, there'd be no reason to get a security clearance.
Yeah, just by the status of the members does not give them access to classified information.
So currently, who decides whether a member of parliament can apply for a secret level security clearance?
The clearances or the process is a very government process. So
Right.
it's the government that will decide if it's required for specific members of parliament.
So this bill essentially allows all members of parliament to access an application, essentially to deem themselves, rather than the government deem them needing to, I'm not going to say need to know, but that they have a right to apply. Now, is not a government decision, it becomes an individual MP decision. Is that not correct? That's the implication of this bill?
It becomes a member decision to apply.
To apply.
And then the government will not be able to say, because of the proposed
Right.
provision, that you do not access to classified information in your functions. So
Got
my
it.
understanding is that those applications are not processed currently.
So, yeah, so I got that. I think that's helpful. So essentially, all 338 members of parliament could deem themselves having a right to apply and could apply for a secret level security clearance. But then the government in the second step may deem them not needing to know in many of those circumstances. Is that not correct? Is that a possibility?
It is a possibility, except that you jumped a step. If they apply first, there's the screening process. So they need to receive the appropriate clearance, whether secret.
Yeah, you're right. I was taking
And
that.
then once they have the clearance, it will be on a case-by-case basis. The government decided whether or not there's a need to know.
So here's my point, though, is yes, that we're using up a lot of resources to do security clearances for individuals who might turn out not to have a need to know information that they've applied for security clearance for. So because we're reversing the onus and we're saying members of parliament can now decide for themselves whether they need to access that information, now there's a lot more resources that would be used to do security clearance and screening for them when they may turn out not to have a need to know the information for which they've applied to get access to. Is that not correct?
That's correct.
So isn't that a waste of resources?
I know that the committee has officials from the government in the second hour, so those questions may be more appropriate for the government. I will also say, and I alluded to this earlier, that should this bill be adopted, my assumption is that there will be some kind of governance that will be established within each caucus, so that not all members will necessarily apply to receive a clearance.
Okay, and the other point that I wanted to make, or other line of questioning, is related to immunity that you mentioned, that members of parliament have immunity from criminal and civil prosecution, I guess. And so if a member of parliament were to go through this process and gain access to information, and then decide to read it into the record in the House of Commons, which has happened in the United States with the Panama Papers, what would be the legal repercussions? I think you've already said that there would be none, right?
Parliamentary privilege will protect the members for having disclosed the information as part of proceedings. There will be no legal consequences. The parliamentary privilege will not, however, protect any members if they disclose information outside of proceedings. There could also be, there will be political consideration, because if this bill is adopted and then members start disclosing classified information in the chambers, I suspect that the government will just stop sharing any information with members of parliament.
With those members or with all members?
That's for the government to, we're speculating here. So
Yeah,
I mean,
we're speculating for sure, but I mean, in contemplating the repercussions of a bill like this, which changes the process, I think we should be speculating on what the risks to national security might be if members of parliament use their privilege and immunities in the House of Commons after gaining access to classified information and revealed that information. They disclosed it publicly. So I wouldn't suggest that any member here would do that, but it has happened in other jurisdictions, and I think it's a risk we should take quite seriously. Do you not agree?
Very
I
quickly,
agree
Mr.
that if members have access to classified information and then there's a form in which they can disclose the information with immunity, that's certainly something that the government will take into consideration when assessing the need to know principle. We have examples in the past, 2 panels where classified information was made available to members of parliament, and there was no, to my knowledge, no leaking of this information.
Thank you, Mr. Turnbull. Madame Gaudreau, 2 minutes, 30 seconds.
Et que c'était un
What a fascinating discussion we have here, Mr. Chair. Earlier, we spoke of the United Kingdom. We spoke about precedent. I'm trying to have a constructive discussion with all the answers we've heard so far. We know that the RCMP and CSIS have the ability to give out security clearances and security clearance levels. I have a concern because they have to, they're in charge of giving the clearance, but they also gather the intelligence that is necessary for us to know. In the UK, they have an independent agency that is completely nonpartisan and offers on a case-by-case basis to whoever would be relevant to have that security clearance. They give out top secret clearance to people who would need it. Would that be a feasible solution here in Canada? I think that this goes beyond the scope of the bill that we're studying today. This bill is very specific. It allows members of parliament to request a security clearance versus this is a public policy question that you're asking, which speaks to the overall approach of how to, with information and security clearance. My concern is national security. We are told that we can be given secret information. We're also told that there could be a leak, and we have been discussing the impacts of the leak, and there is talk of speculation, of course, but we need to really be careful. So I will clearly be asking this question to CSIS. Thank you, Mr. Chair. I yield my time.
Okay. Vous avez fini?
Nothing else? All right.
From time to time, I get caught up in discussions with the clerk. Ms. Matheson, the floor is yours for 2.5 minutes.
Thank you, Mr. Chair. Just, I guess, a continuation of the discussion again. So in the United States, senators have similar protections to our parliamentary privilege. There was a case where a senator had used his privilege to publish. He had received information and he was told he couldn't publish it, and he found a back way, I guess, or a subcommittee because he was the chair to publish that information. This ended up actually going through the federal courts. It went to the Supreme Court. It was ruled that they upheld his parliamentary privilege, or his, whatever that American equivalent is, his privilege. Has there been any study from your, as the legal expert on this and all things legislation, has there been a similar consideration of just how a Canadian context would be applied here if such a thing were to happen?
In the context of Bill C 377, there is a saving clause for parliamentary privilege, and the parliamentary privilege are not affected. So the intent of the bill
could be
is,
no challenge. It couldn't
no,
undermine.
if members gain access to more classified information, there's no exception to privilege in the same way that is created for the NCCOM members. NCCOM members cannot disclose information in the chamber and committees because they will be subject to the Security of Information Act. Here, the information that will be provided is not subject to the same exception. So a member could disclose the information in the chamber, in committees. That said, and I think that this is relevant to the example that the sponsor of the bill refers to when talking to the bill, we have certain recent examples, for example, specific briefings where there might be foreign interference, and there's a need to disclose classified information. I don't believe that this is the type of information that the member will then disclose in the chamber if it's very personal about the member. And again, there's always the need to know test or principle that is applicable, so it's the government ultimately that decide what information it is comfortable in sharing with any specific member.
And we had heard at the last committee that this would undermine NCCOP. Is there any belief that this legislation would undermine NCCOP from your perspective?
I think it's two different subjects. NCCOP have a very specific mandate, and the bill, if passed, will allow certain members to have the secret clearance accreditation. If committees are to undertake more studies in relation to national security and they exercise their right to send for records and papers, that will be a parliamentary order, a parliamentary decision, has nothing to do with the clearances of the member of the committee may have. The member of the committee may have.
Thank you very much, Ms. Matheson. Colleagues, that brings us to the end of the first round. Ms. Romanato, did you have something you wanted to add?
Thank you very much, Mr. Chair. And I don't think this is a question for the law clerk, but I have a question for the committee members. We didn't consider inviting Ian McDonald, who is the head clerk of committees, to this for this study. And the reason I'm asking the question is I'd like to understand the implications. I'm thinking in French of on committees. So if a committee like ours is doing a study on foreign interference and we want to have access to specific information that is deemed as classified, how would it work and how would this affect committees? So I'd like to ask the committee members, I don't want to delay, we're doing clause by clause, I believe, next week. If it's the will of the committee, could we perhaps have our clerk write to Ian McDonald asking him specific questions so that we can consider that the implications, thank you, of this bill passing on committees. I'd just like to get, if that's okay with the committee, I don't want to delay it. Could we write to the clerk, the head clerk, and ask how would this pratico-pratique function? I just want to ask everyone if they're okay with that. Again, not to delay this at all. I'd like to ask what that would be.
Lindsay?
Wouldn't it? I don't have a problem with that. And I know that we don't want to delay too much, but wouldn't just an hour with Mr. McDonald work for everybody? Instead of making it, because potentially writing it all down, like, I can
So-
see that, and then maybe not getting it back in time, and what are the deadlines, but maybe just an additional hour of that witness if everybody's amenable.
Yeah, I caution against that only because we've got clause by clause already planned. We've got a question of privilege that's very likely coming our way in the immediate future. That's going to disrupt the schedule we already have, and I suspect we may need time if we get through clause by clause in a efficient manner to go into committee business to talk about the question of privilege. We've got a harassment study that's supposed to pick up on Thursday if we keep it. We still need some witnesses for that. So my own 2 cents, Ms. Matheson, I appreciate the suggestion, but would be that for the sake of keeping us effective and efficient in our planning purposes, that a written testimony, should that be the will of the committee, perhaps is the better route to go. Mr. Ruff, I know you wanted to speak to this briefly.
Yeah, look, I have no concerns with the ask. However, it really has nothing to do with my bill because it is dealing with that next step that should a committee down the road ever decide that they want to get access to secret information, no different than the special committees that we've referred to already a number of times. That process, then the House of Commons assists in working with the security agencies to set up the appropriate protections necessary to have those meetings in a secure location or to handle the files, etc. So will there be implications? Absolutely, but it's not really that relevant to my bill because my bill is only addressing the fact of applying for a security clearance. So I have no issues with the ask. I just don't think it's really relevant to the actual study of the clause by clause of C377.
Okay, thank you. Oui, Madame Gaudreau.
Considérant
I think that we need to be constructive and efficient here. Could we wait for our next witness and the few minutes at the end of our committee meeting to then see if a question could be asked without hindering the little time we have left? Because I'm thinking of the resources we have with us today and also with the deadlines. So we're lacking about an hour for me to say it's a great idea.
We're going to suspend, as per originally planned, to transition over to our second hour. I would ask members to speak with one another during the suspended break that we have, see if we can find consensus on this, and then we can decide whether or not we want to provide some direction to the clerk on that basis. So thank you, all of those who offered commentary. Monsieur Bédard, Madame Gauthier, thank you very much for being here with us today. Colleagues, we're going to suspend, and we'll pick up in a few minutes. Going with our second hour of testimony. We've got a number of witnesses with us here today. So I'd like to welcome from the Canadian Security Intelligence Services, Nicole Giles, who is the Senior Assistant Deputy Minister of Policy and Strategic Partnerships. Bo Bassler, the Director General and Coordinator Foreign Interference. Sean Jorgensen from the Privy Council Office, who is the Director General and Chief Security Officer. From the RCMP, we have Superintendent Jeffrey Bolak, the Acting Chief Security Officer, Departmental Security Treasury Board Secretariat. And we've got Mike McDonald, Senior Assistant Deputy Minister, Security Policy Modernization. Thank you very much to all of our witnesses that are here today to add their insight and guidance as we delve further into Bill 377. Ms. Giles, I understand you'll be speaking on behalf of the entire group, so I will turn the floor over to you for 5 minutes. Just a friendly note to our witnesses, if you're not used to appearing in front of committees, you have these earpieces. If you are not using them, please just make sure you place them on those stickers in front of you. Obviously, if they're on your ears, then you can go ahead and use the function as normal. So with that, Madame Giles, 5 minutes to you.
Good morning, Chair and members of the committee. It's an honor to join you today and to have the opportunity to discuss Bill 377. We hope to be able to provide some insight to this committee on government security screening processes and policies, as well as on access to classified information and the importance of protecting it. In the interest of time, as the Chair mentioned, I have the honor of providing opening on remarks on behalf of the entire panel of witnesses. Le filtrage de sécurité est une pratique.
Security screening is a fundamental practice that establishes and maintains a foundation of trust within government, between government and Canadians, and between Canada and other countries.
Screening involves the collection of personal information from individuals with their informed consent, and information from law enforcement and intelligence sources and other sources and methods to assess an individual's reliability and loyalty to Canada. My colleagues here from TBS and PCO will be very pleased to be able to expand upon these issues. A security clearance is sometimes misunderstood or portrayed as a special designation, a set of privileges, or an earned qualification like a rank. It is none of these. Simply put, for the Government of Canada, it is an administrative decision that's taken by a deputy head of an organization that an individual is an acceptable security risk to access government information, assets, and facilities, and to work with others in government. Cet administrateur ou administratif général.
The deputy head makes this decision taking into account information and advice provided by law enforcement and intelligence agencies, including the RCMP and CSIS. A security clearance can be granted, denied, or revoked at any time by the deputy head.
Clearance holders work in every part of government. A security clearance does not automatically grant the holder access to all information or assets at that level of clearance. Safeguarding sensitive information is critical to the Government of Canada's ability to function and to keep Canada and Canadians safe. There are rigorous measures in place to prevent the release of classified information to anyone that does not strictly require it. These measures are imposed with very good reason. The inadvertent release of sensitive information can result, and very sadly has resulted, in serious harm to individuals, even costing lives, Canada's national interest, and our international relations. Mitigating this risk underpins everything that members of the security and intelligence community does. The release of information could mean risking the safety of human sources, exposing the tradecraft and other methodologies used to conduct investigations, and threatening the stability of indispensable allied relationships upon which Canada depends so heavily for intelligence. Put simply, if partners cannot trust Canada with its information, they will no longer provide it to us. Similarly, if human sources do not trust that CSIS can protect them by safeguarding the information that they provide to us, our ability to recruit sources and collect information vital to Canadian security will be seriously impeded. If we could also lose access to a valuable technical collection source that took years and expensive investments to develop. What may appear in the first instance is information that's not especially sensitive or harmful. When viewed in conjunction with other publicly released information, can be used by adversaries to make inferences with very serious consequences. This is called the mosaic effect. Our adversaries carefully watch and track every word we say and release publicly, and we're very confident that they are watching now. They put together many pieces of information to identify our sources, our methodologies in tradecraft, and our intelligence gaps. And many adversaries are very good at their jobs. There are important principles that reinforce this system and that lie at the foundation of safeguarding all sensitive information. This is the need-to-know principle. An individual's specific duties and functions and the files they were working on at that particular moment in time is what establishes their need to know for relevant sensitive information. Even the most senior officials at CSIS who have the highest possible clearance levels do not receive sensitive information that is not relevant to their current job and the current files that they're working on. In other words, there is no deemed need to know. We need to ensure that sufficient information is disclosed to hold the government to account, while also ensuring that classified information is protected. There are several critical avenues for review and oversight of classified information, including the National Security and Intelligence Committee of Parliamentarians, the National Security and Intelligence Review Agency, the Intelligence Commissioner, and the Federal Court, amongst others. Celles et ceux qui travaillent pour ces organisations ont
The individuals working for these organizations have the required security clearances, and individuals received classified information that they need to know in order to execute their specific duties.
In place to ensure that no national security injury occurs as a result of a disclosure of that information. These individuals are bound to secrecy under the Foreign Interference and Security of Information Act, formerly known as the Security of Information Act, SOIA, and must not disclose knowingly any information they obtained or to which they had access in the course of their duties, and that a department is taking measures to protect. Parallèlement, le SCRS.
At the same time, CSIS is taking efforts to increase transparency, such as through our annual public reports, which reveal more information than ever before about our operations and the threat landscape, as well as through media engagements, proactive public disclosures, and more.
For example, to write for release information. For example, the proactive provision of chronologies of events to parliamentary committees, and we've done that in the last couple of months. Recent amendments to the CSIS Act through Bill C-70 further enable CSIS's ability to share information, and we look forward to working more closely with parliamentarians as we up the national security conversation in this country. C'est avec plaisir que nous répondrons à...
We are pleased to answer your questions. Thank you.
Thank you very much, Madame Giles. With that, Mr. Ruff, the floor is yours for 6 minutes.
Thanks, Chair, and thanks, Ms. Giles, for the opening remarks, and thanks for everybody here for what you do on a daily basis to help keep our country safe. Some very familiar faces sitting at the table. Look, Ms. Giles, you talked about the threats. You talked about the need to up our game. You talked about the important changes that C-70 allowed that's going to allow CSIS in particular to share additional information. However, one of those conditions upon sharing additional classified information, and we're only talking at the secret level here with my bill, is you're still going to want those people to have a clearance before you share that information. And when that could be other levels of government, that could be, but in particular with here with C-377, parliamentarians, so MPs and senators. So that's a necessary safeguard that they're going to need in order to get that information, correct? And I would just ask, is that part of the reason why, this was, evident and brought forward by CSIS, whether to NSICOP through reporting up to the government, that why it was included in C-70, is there is that recognition. More classified information needs to be shared at a much wider level in order to address the ongoing security threats.
Mr. Chair, I think those are excellent observations and perhaps two comments to offer. So first of all, one of the changes that was made to Section 19 of the CSIS Act as part of Bill C-70 really removed what essentially was a prohibition from CSIS sharing any information or analysis outside the federal government, including unclassified information. So what those amendments enable us to do is to also provide a lot more unclassified information and advice and expertise in a way that we couldn't before. And so that's enabling us, for example, to participate with allies in multi-branded security advisories in a way that perhaps we couldn't before. So it's also to enable sharing of unclassified information that we previously couldn't provide. And as the member mentioned, this gives a great opportunity for us to have a far more sophisticated national security conversation. Now, in some particular cases, there will be specific pieces of information that are classified that we would like to be able to share outside the federal government to those that have the appropriate clearance. So, for example, there could be a situation where there is a parliamentarian who's representing a particular constituency where we know a foreign interference actor might be interested given the natural resources in the area or a particular ethnic or minority community that makes up the riding. What we would like to be able to do is to be able to provide that specific, perhaps classified information to parliamentarian to be able to enable the parliamentarian to build their resiliency by being able to recognize and then, as a result of that, being able to manage the threat. And so that's the purpose of the changes to the CSIS Act, is to allow us to be able to do those resiliency disclosures. So sometimes it'll be unclassified information, sometimes it would be classified, but classified information would only be provided to those who do have the requisite clearance. But in each of those cases, there would need to be a determination by the owner of the information as to whether there was a specific need to know for that particular specific piece of information.
My next question, Mr. Jorgensen, will go to you. We had some interesting testimony here on Tuesday, and just to be upfront, you're the former Director of Operations, if I got the title right, for NSICOP since its formation, really. And we got testimony here by Mr. Work that said somehow that if parliamentarians just even applied and were granted a secret security clearance, it would be the fatal to NSICOP. In your opinion, would just having parliamentarians with a secret security clearance somehow undermine NSICOP?
Thank you very much. Through the chair, I'm not sure that I would go and criticize Mr. Work for his opinion. Obviously, that's his opinion. What I would say is what he's getting at, I think, if I were to interpret his remarks, is the issue around safeguards. And in fact, Parliament has discussed safeguards in the context of NSICOP before. So you'll recall, Mr. Ruff, you yourself went through a clearance, is what we're discussing here. But there's more to security in the Government of Canada than just a clearance, as you well know. And so if you look at NSICOP, for example, every member there is permanently bound to secrecy. They have given up their parliamentary privilege, and in fact, if they say something, divulge something in Parliament, that information can be used against them in a court of law. They've taken an oath. And the other thing I would emphasize, though, that Parliament allowed the Governor-General to do was pass regulations. And those very regulations set in place all of the very safeguards that I think that Ms. Giles covered very well. And that is around who can do what, when can you share the information, how can you process it, what do you need to use. All of those safeguards is what makes up, I think, I hate this word, but the ecosystem of security in the Government of Canada, of which security clearance is one part. So I'm not sure I'd agree if it's fatal. We already give clearances in certain circumstances to MPs. The NML issue is one, NSICOP is another. But I think that all of those were buttressed with the safeguards that we're talking about.
So just really quickly on the NML or the Winnipeg Lab stuff, is there any awareness from the officials here of those MPs that did not waive their parliamentary privilege having leaked information, utilizing their privilege in the chamber?
I can't say that has been the case, but I would also just remind everyone here that they also took an oath not to do so.
Thank you very much, Mr. Ruff. Madame Romanato for 6 minutes.
Thank you very much, Mr. Chair, and through you, I'd like to thank the witnesses for being here today. And I think it's a great panel because I think the witnesses here today can kind of walk us through the process. So I want to make sure that everyone understands that currently how would one obtain security clearance? And if I'm understanding correctly, there needs to be an administrator or someone who deems that the person who is applying for security clearance, there's a reason they need it. There has to be a justification for that. Once that is made, they can apply for the screening. They go through the screening. They have to pass said screening. There's a recommendation, I believe it's, in some cases, CSIS would do the screening, make a recommendation saying yes or no. And that, at that point, the person would get their secret clearance, again, in the case of secret clearance. But once they have the secret clearance, it does not mean that they can access every secret document in the Government of Canada. Is that correct?
Yeah, Chair, I'll answer that question. Parts are correct, and parts perhaps I can provide a bit more clarity. And I'll be brief, because it's not a short, simple process at times, and other times it can be. The easiest thing to say is security screening, the way it's conducted in the federal government, it's as per a Treasury Board standard. And that standard lays out the responsibilities of those who actually take security in a department, and one of their jobs will be to do security screening. Essentially, the process starts, and you were correct, where a person is considered for a position or will be going into a position or being hired by the Public Service of Canada. Therefore, they're deemed, maybe not the right word, but therefore they are needing to require access to a facility, access to assets, access to information technology, and so on. So they have a need in order to have a clearance. Basically, the process begins with someone, you're considered for a position, there's information, assets, and facilities. You don't ask for a clearance. Your department has decided that you need it. Then you, as a candidate, you provide a range of information about yourself, right? So you fill out forms. Some of you may have done that in the past. And then the department collects that information about you, and you are aware, in fact, you have to consent to all that. So that's a key part. You're consenting to your personal information and so on. You can look at things like work history, financial information records, records of engagement maybe with law enforcement in the past, your habits, personal habits, your behaviors. There are searches of intelligence databases. There could be searches of the internet, for example. There could be searches of national security holdings, and some of your, your social media behavior and so on. All of this will be captured, more depending on what level you are looking at getting. Could be a top secret, could be a secret, or could just be what's called a reliability status, which is the lowest. Essentially, then, the decision maker, like in administrative law, takes in all of this information, will send off a CSIS assessment if required, a request for, or a law enforcement check, request for, or a financial check if that's required. But basically, we'll take all this information, and then that person has to go through a judgment process. Well, they'll take the totality of the information and think through, okay, is there something that is causing concern, something that would question their judgment, their trustworthiness, or their reliability? If you're going to secret or top secret, you will then have questions around loyalty to Canada and reliability as it relates to their loyalty. I'll be very quick. If you come up to something where there is a concern, you may be called in for further security screening questions. If not, you will proceed through the process. And it's important to say that if you do not get a security clearance, there is a right of redress, and there are steps that one must follow in order to address that redress. And the applicant has steps to follow if they disagree with the redress process.
So what I want to get to, though, is in this bill, the intent of the bill, as per the sponsor, is that first step. Because members of Parliament, we do not have an administrator or someone saying this person's job requires them to have access to those assets, information, technology, and so on. But from what we heard last panel, there's two steps. One is what I'd like to call is the justification or reason to apply, that first step, that administrator step. And then the second one is once you've passed your security clearance, the need to know. The fact that the reference to the words need to know are in this bill, which can cause some ambiguity in terms of what are we referring to here? Are we referring to the application part, or are we referring to once you've passed all of that, you now have a need to know? So in your opinion, would you recommend any changes to this bill that would just eliminate any ambiguity or remove any little bemol that you may have with respect to this bill? Because I understand the intent is really about MPs, parliamentarians applying, but is the concern that we've heard about the need to know is because it's in the second step in terms of the access to this information?
Mr. Chair, if I might, I think we're, of course, as officials, never in a position to provide policy advice on specific pieces of legislation. But I think that there is often some confusion around language and vocabulary. And the term need to know is understood differently in different contexts. So when we talk about need to know, that applies to each and every individual specific piece of information. And so therefore, in our work, there is no deemed need to know on any piece of information. It's the originator and the owner of the information that determines who gets access to it. And even to give you an example, when we get information from an international partner and we want to provide it to the RCMP, for example, for a law enforcement investigation, we have to go back to the international partner, CSIS, and say, can we use these exact words and give this exact information to RCMP for the purposes of a criminal investigation? So it's very regimented. So I think from our perspective, there's always value in being very precise about the language that's used. And in our business, in our world, there is no deemed need to know on pieces of information. It's determined on the basis of that very specific circumstance. And, there are a number of meetings that I'm not allowed to be in every day because even despite my position, I don't have a need to know for that specific operation, for example.
Just to clarify, I have way too many as well, and I really don't want to be in some of those meetings, so thank you.
Thank you, Madame Romanado. Madame Gaudreau, à vous pour 6 minutes.
Merci. Thank you. Thank you so much for giving that information. In your opening remarks, I've understood a lot about the difference between the right to know and the need to know. What I'm concerned about is more this effect on parliamentary privilege. As a parliamentarian, can I have access to information that will help me in my role as a lawmaker? Where I was concerned was when you talked about the international relations, especially with our Five Eyes country, with our Canada's reputation and the CSIS potential, the impacts on CSIS. I also heard you say that Bill C-70, which I believe lacks teeth, has also contributed to providing additional information to us so that we can potentially avoid something that we're going through right now in the legislature, which is an issue that's going to be before PROC very soon. I'm trying to think about how would this bill, that is Bill C-377, be advantageous in a context where I could be informed if I had a need to know and if there was an appropriate request that was made, unless the government decides not to authorize that access. Could you comment on that, please?
Je pense que ma question était très bonne, Monsieur le Président.
I believe my question was crystal clear, Chair. Yes, thank you for the question, Chair. I think that it's not as simple, as straightforward as that. It's not up to the RCMP to decide how to enforce the law that parliamentarians write. The concerns of my colleagues were well explained. The concerns and definitions can be vague, that is true. It's not just the international reputation that bothers us, but also domestically. As a national police force, we maintain relations with police forces across the country, as well as other law enforcement agencies. And the holder of such information has the right to decide when and how such information is used. At the RCMP, we diligently take care of all the information that we are aware of in order to ensure that we're protecting it to not hinder our ability, nor to not hinder our international partners' ability to do their work. So if I understand, Chair, there's a difference between the information I have and what I would do with that information. And we're talking about a monitoring of this information. Maybe if the CSIS officials could comment. Maybe I would ask my colleague to provide a bit more information.
The perspective of our international partners, what they're really requiring from us in order to continue providing information and really critical intelligence is that they have confidence that the information that they give us will be protected. And that if we choose and get their permission to pass that information on to others in the Canadian government or external to the Canadian government, that there are appropriate frameworks and measures in place to ensure that there isn't the onward distribution of that information even further. And so I think from our perspective, that's the really critical piece, is ensuring that those intelligence sharing agreements that we have, that we can live up to our obligations and that we can protect the information. And this is something that's so critically important to us. We are a double-hatted intelligence service. We both do domestic and foreign, and we are a relatively small intelligence service. And so we are very dependent upon the information that our intelligence allies give us to be able to do our job and to protect Canadians. Now, what we produce is very desired by our partners and allies, but we ultimately are also net importers of intelligence, and so we need to be able to provide those assurances and have those frameworks in place. And that's why that need-to-know principle is so important for us.
The one piece I'll add to Dr. Giles's comments is with our international partnerships, when we develop the sharing frameworks and mechanisms, how we use the information is spelled out as part of those mechanisms at the start, but it is also contained in each piece of intelligence that we exchange. So the intelligence will come to us, or our intelligence will be shared with a partner. Conversely, it will say, the security level at which it must be kept, but it will also say how that information can be used. So often when we receive a piece of intelligence, it will say this may be used by your department or by appropriately cleared members of the Government of Canada for investigation, for intelligence, but not for court proceedings, for example. So each piece of intelligence is specified how it may be used by whom, which I think is a critical element in all of this as well. And if we want to use it differently, that's where we go back to the partners and we say, okay, now we may want to use this as part of a court proceeding. Can we use it in an affidavit, for example?
Merci, Madame Gaudreau.
Thank you, Ms. Gould.
Ms. Matheson for 6 minutes.
Oh, I have so many questions. Can you just the sponsor of the bill with us today referenced many times over the numbers of people who currently hold security clearance, and it's about 100 or 250,000, and that only 23 have been rejected. Can you go through those numbers for me a little bit in terms of, and also when you get security clearance, do you always keep it? I know that there's a revocation of it if necessary. However, how long does that last? And in terms of when members of, where I'm getting at is where members of Parliament, if they're allowed this access, how CSIS will handle that in terms of, or whoever provides, not CSIS, whoever provides the clearances, how will they handle and manage that in terms of numbers, if that's even an issue?
very briefly, and then can ask colleagues to comment. So CSIS's role in the security clearance, the government security screening process, we also do immigration security screening. It's a separate program. But our government security screening colleagues, they provide advice to the deputy head who has requested the security clearance be undertaken and done. So we're not a decision maker. We don't keep track of who has clearances. We provide advice on each individual case to the deputy head who has requested that we do so.
Chair, thank you for the question. Here's the statistics as best as we can gather them. Because remember, each deputy head of an organization controls the clearances or the reliability status that is given in an organization. So I can say this. For government employees, every person in the Public Service of Canada has to have a reliability status, which is good for 10 years, right? Okay. So that's 100%. So you're at 360,000 plus. Roughly 51% of individuals will only have a reliability or an enhanced level of that. 40% roughly of the Public Service of Canada has a secret. And then roughly 8-9% will have a top secret or top secret enhanced. So the pyramid gets very small the higher you go up. Now there are we do know roughly 110 to 130,000 contractors are screened by PSPC as part of their program per year. And the last bit of data that we do have a good sense of, when you look at new hires coming into the public service, about 1 in 400 plus to 500 actually don't get a clearance. That's for new hires. But again, this is not absolute data. This is the best that we can glean. That's for new people who are coming in and making an application into the public service. So in other words, denials are given. Secret clearances, you have your I believe it's 10 years, right? Secret clearance and 5-year renewals for top secret. So that's how the system kind of operates very briefly.
So who would be in charge then, if this goes through in a hypothetical, what deputy head would be in charge of those general members of parliament's clearance?
If you don't mind, I'll take that. So I must say that is an area that is ambiguous in the bill right now. Up until this point, it's been the Privy Council office that has done that. So for MPs who came in for NML or for NSICOP, it goes through my shop, and then the decision to grant or revoke would rest with either me, or if it's a revocation or denial, would vest with the clerk of the Privy Council.
Do you have the capacity to handle an onslaught of 343 potential members? And then how long would that, so, and then again, how long would that security clearance last for? Would it last, I know it's not dictated in the bill, so maybe this is part of that clarification. However, how long would that security clearance then last? Would it be the automatic 10 years or?
So that's another good question. It's not clear in the bill as to essentially, is an application going through the process that was set up and built for the public service? And if that is the case, then they would last for 10 years.
Okay.
And then the revocation is another question I think the committee would want to think about, is what would be the implications if a member of parliament were denied a clearance, or that through whatever case was revoked a clearance? What implications would that have for the individual member of parliament, for their party, for the caucus, for the leader of that party, parliament more generally?
So currently the revocation would sit within the deputy head's, I guess, Authority, thank you.
Correct.
Sorry. Clearly need more caffeine. So that would be a problem.
30 seconds here, Ms. Matheson.
But okay, and then what if if our security clearance lasts 10 years, what if the member doesn't?
So once you would leave Parliament, your clearance remains valid for a year in the event that, for example, this is how it works in the public service, is that if you come back to a job, that it would be renewed. Otherwise, you'd have to get the clearance done again.
Okay. And then the other revocation, like, that hasn't been thought through in terms of say, as a member of Parliament, I wanted to have somebody else. If I found somebody else, like, is there a process that of challenging that security clearance, or?
So again, unclear, but there are processes for a public servant to challenge the revocation or the denial of a clearance, and that happens at the reliability level, a different group, and then for a secret or a top secret goes to NCIRA.
Thank you, Ms. Matheson. Mr. Duncan, the floor is yours for 5 minutes.
Thank you. Mr. Jorgens, I'm going to direct my questions to you here. Just when we talk about the right to apply for need-to-know status and have a security clearance, the Chief of Staff to the Minister of Public Safety would be deemed to have the right to apply, and they have a security clearance, correct?
That is correct.
Okay. Yeah, so I'm going to give a bit of a list here.
Sure.
So at the Ontario desk, the minister's staff that works at the Ontario desk for the Minister of Transport, they would be deemed to have the right to apply for need to know, correct?
No.
Any ministerial staffer that applies, there's a rule here. All individuals who work in or for the office of any minister, including exempt staff, other employees, contractors, students, persons on loan, assignment, or secondment, regardless of their work location, require a Level 2 secret security clearance prior to appointment.
I'm sorry, that is a mistake on my half. That is true.
Okay.
You need a secret.
So next, the driver that's employed in the Minister of Health's office requires that they have a need to know and the right to apply, correct?
A security clearance does more than just give you the right to know, or it doesn't give you a right to know.
Gives you the right to apply because they need to know. They're deemed, they must have it in order to be employed.
Yes, sir. We need to make sure, though, that person who is employed in that position can be trustworthy with the information that they
I'm not disagreeing with that. The intern that participates in the Liberal Party's internship program for 2.5 months in the summer in the Minister of Democratic Institutions office requires a security clearance to work in that office, correct?
I'll take your word for that.
That is, they have to. I read that, they do have to. So my point is that you come here today and you say that there's some resource and capacity issues, that you've issued 250,000 security clearances in the last decade, and that 338 MPs might apply is a bit of a challenge. I find that a bit difficult. When I'm looking here as a member of Parliament, Mr. Jorgensen, I'll ask you just as a high level again, in the budget in the office that you work in, who approves and votes on your budget each year?
You do, sir.
Yeah. And so the intern at the Liberal Party of Canada's summer internship program is automatically deemed the right to apply because they need to know or might need to know at some point in the course of their work. And we're having this pushback here today that a member of Parliament to have the right to apply for that same status is suddenly an issue for some reason. I go back of where when we talk about capacity and we talk about a challenge, I'm saying that there's a frustrating point when it's required to have this and capacity is used and questions are used of a pushback. The point being is that members of Parliament should have the same right to apply. What comes afterwards in many conversations today of where it's frustrating is we have this challenge. So maybe my question, you won't be able to provide this in writing, but I just want to give the context and hammer it home. If you could provide in writing to us, how many intern applications have been applied for and approved, say, since 2021? My point being is, when there's 338 MPs that might apply and be given the right to apply, I go back at the end of the day that it is very reasonable to be able to do that. And as members of Parliament who vote on the budgets that you work under, that vote on legislation that you enact and enforce, I don't think it's unreasonable or there shouldn't be any challenge that this cannot be met. So I think that's one of the things, if we could have that provided in writing about the number just to provide us a context, I think hopefully what I've been able to outline is we can get to yes on this. This is reasonable. It's very fair for members of Parliament to have the right to apply. And considering who is already deemed have the right to reply on the need to know status, Mr. Ruff's bill on that is, I think, wholly appropriate and doable. I don't know if you have any comments on that.
Well, Mr. Chair, if I may, I apologize if I've left any misunderstanding. I did not say at any point that my team could not do this. We absolutely can do this. It will take some time, but that's true across the government. So I want to leave the the fact that I have not said we have an issue with responding to this type of demand.
And I would go back and saying is not so much that of capacity being a challenge. Other ones have been raised about the volume. My point being is there's an opportunity and there's a way to get to yes on this. The volume of what's being asked here, and again, I think a lot of the conversation over the course of the couple of meetings has been the other stage about having access to it, but the right to apply and the capacity to do this is very reasonable. So to suggest you've outlined could be something, but other questions that have been raised about this in the last few days. So I leave it at that and just provide that context again, that if a Liberal Party intern, as an example, has the right to apply and need to know status because they work in the minister's office, make the argument Mr. Ruff's bill is very reasonable that members of Parliament should have the very same right to apply, and senators.
Thank you very much, Mr. Duncan. Mr. Duguid, the floor is yours for 5 minutes.
Thank you, Mr. Chair. Thank you to all of our witnesses for their testimony today. I listened with interest to Mr. Work's presentation, and I'm sure you listened to it as well. Strong opinions he has. He referred to the Five Eyes and our international partners, and that they would not view this legislation very favorably. And that they do not have this kind of provision as proposed in Mr. Ruff's bill in their systems, and they are looking at NSICOP and other innovations that we have introduced very favorably. I wonder if you might comment on his testimony, whether you agree with it, and maybe just summarize the risks that you see with passing this legislation. I haven't heard a crisp opinion from you in terms of whether you support or don't support C-377. And then I'll cede my time to Mr. Turnbull.
Mr. Chair, I can take a crack at that, which is an excellent question. What I can speak to perhaps is how our closest intelligence partners manage similar situations. And the way that our closest intelligence partners manage is that they also face independent scrutiny by designated parliamentarians, similar to Canada. So, for example, the US FBI is overseen by specialized congressional intelligence committees. The UK's security service is overseen by the Intelligence and Security Committee of Parliament. The Australian Security Intelligence Organisation is overseen by the Parliamentary Joint Committee on Intelligence Security, and then similarly for New Zealand with a different acronym. But what you'll see is the consistency in how allied partners manage this is that there are designated parliamentarians who are cleared to the appropriate levels, who receive, based on the reviews and the specific files and issues that they're looking at, the information they need to be able to carry out that function. So it's very much about entrusting a designated group of individuals to carry out that function, similar to what NSICOP does for us. I think we would be in a bit of a difficult position to be able to speak to the views of all of our international colleagues, but what I think would be fair to say is that there would be, and there always is, concern when there's a possibility that they or we, as a designated intelligence service within Canada, would lose control over who gets access to specific pieces of information. So I think that's where it circles back to being very clear about the vocabulary around need to know, that having a right to apply does not equal having a need to know.
So I want to just follow up on previous line of questioning with the law clerk who was here before this panel. And I had asked about the immunities and privileges of members of Parliament, and worried, which I am, about the risks associated with, as we've seen in the United States and I think in Australia, certain cases where members of Parliament or senators, parliamentarians have used their immunity to reveal sensitive information in parliamentary proceedings that, you know, one could say might undermine our national security. So I have that concern. Do you share concerns that this bill might increase disclosure risk related to sensitive information? So I'll ask Ms. Giles and then Ms. Jorgensen, please.
From the CSIS perspective, whenever there are not frameworks in place to prevent the onward disclosure of intelligence, we're concerned, both about our own information and the protection of our own technical and human sources in our analysis for reasons I explained, but also the concerns that our allies would have who give us specific pieces of intelligence for very specific purposes. So we are always concerned about the onward distribution of information. We spend a lot of time thinking about that and making sure that we have frameworks in place to prevent it. Our understanding currently of the bill as constructed is that there is not currently those frameworks built in, and that might want to be something that Parliament considers and this committee considers.
So, Ms. Giles, can I just be really clear? Does this
quickly,
increase
Mr. Trump.
onward disclosure risk? Does this bill increase onward disclosure risk?
Whenever the frameworks are not in place to prevent onward disclosure, the risks are increased.
And this does not provide that framework. Is that correct?
As I
bill?
understand, and as the bill is currently written, there's an opportunity to put frameworks in place that would help to mitigate risks. And I think Mr. Jorgen spoke very eloquently about the measures in place for parliamentarians and NSI COP and how that onward distribution is prevented.
Thank you very much. Madame Gaudreau, 2 minutes 30 seconds.
Ms. Gaudreau, you have 2.5 minutes. Just want to make sure I understand this. I'm currently in a study at a committee. There's a classified document that standing members of a committee should have as declassified. I can then make a request. I then need to go through to have that security clearance, to have access to that information that would be specific to the request at hand, classified, a secret document.
I think, to Mr. Jorgensen's point, going back to other procedures that have been in place for other parliamentary committees, if there is a requirement for a parliamentarian to see a specific piece of information and that need to know has been established, then that's when the conversation would ensue about how the documents would be provided and the best mechanism to provide them. Because one of the things that we're also very concerned about is how the information is protected once it's...
I'm sorry, I don't have a lot of time. For example, with Mr. Johnston's report, it would have been relevant to have access to that. I could have applied for a security clearance for that document, considering the need to know bestowed upon me by my position.
We certainly would not want to become involved in how parliamentary committees request information and how that information is provided. We work in collaboration with Parliament and our Privy Council.
I understand. What I'm seeing now is that there is a filter that is very important. At one point, it could be a liberal government. Well, now it's a liberal government. It could be a conservative government in the future. What's important is the disclosure of information in order to properly do our work. Currently, the bill offers a way to go around that principle and find another way to get access to information. At the end of the day, if a committee is requesting information that could be declassified, we wouldn't need weeks of questions of privilege in Parliament to deal with it. I'm wondering, does this bill have enough teeth, and will it allow us to go even further? Because at the end of the day, if it's a matter of Parliament's right to know versus the whims of a government in power, is this a similar situation? Can you comment?
The need to know, I think you've heard a lot about today, and so I won't go through that again. I think the issue you're getting at is, would a member of Parliament who had a clearance, would that allow the government to provide the information that's being requested more quickly? And I think the answer to that would be, yes, it would. The need to know, though, still rests with the government itself, the government of the day. But that's not what the bill says.
Oui, merci, Madame Gaudreau. Malheureusement.
Thank you, Ms. Gaudreau. Unfortunately, you're out of time. That's that. Do you need any additional information? I think it'll be all right. I have heard enough information to interpret the situation correctly.
Listen for 2.5 minutes.
So I guess carrying forward in terms of the checks and balances that are there or not there in terms of this bill and where we're left. When someone gets these security clearances, is there like a I mean, there must be some sort of training or education that they undergo. That isn't necessarily provided, I guess, within this legislation, but is that possible to ensure so that members of parliament understand their obligations, that they understand the difference between evidence versus intelligence, and how would you prescribe that to go for members of parliament specifically, within our rules? And I know that depends upon the actual information that may later come, but generally, I guess.
So that's a great question. So if this is going to be the way that we currently use it under the TBS guidelines, then you get your secret, and then you get a clearance, and then you get a briefing on how to handle that information. But the other thing that I would point out to you is that there's an obligation thereafter for you and for the CSO, the person who gave you that clearance, to monitor your compliance with the obligations that you have under the SOIA, for example. Those are things that this committee would want to think about, because that is part and parcel of when we give a clearance, we want to make sure that people who have that clearance are abiding by the obligations they have, and that can be a cause for revocation.
And that would happen like every year, or that would...
It's an ongoing obligation. It's an obligation on the individual who has the clearance, and it's an obligation on me and other CSOs like me to continue to monitor their compliance with the regulations, I would say.
Okay. That's the only question I had.
Thanks, Ms. Matheson. We're going to end with just 2.5 minutes each remaining. So, Mr. Ruff, 2.5 minutes for you, followed by Mr. Turnbull.
Yeah, well, thanks, and again, thanks for coming here today. I just want to make it crystal clear to everybody here that this bill only does the first step, that allows members of parliamentarians to apply for a clearance, and there's nothing in this bill, the way it's currently written, that would allow access to any information. It just allows the application, the ability to apply. Is that clear to all the witnesses?
Your comments are clear. The bill, when we read it, I would say that we have concerns about the ambiguity of parts of the bill.
So that's great. Then if we added a line in or something to the clause that states the application, this bill is for only the application of a secret security clearance that would follow current Treasury Board guidelines, would something like that reassure the officials?
I think the point I would make, again, Mr. Ruff, is that we see in other legislation that's been passed by Parliament the safeguards and the follow-up that would give, I think, this table more assurances that the Parliament has done this before.
But Parliament has done this before with, again, the NML situation, the Afghan detainee files. My bill does not address giving anybody any information. It only addresses the application for a secret security clearance. So I guess what I'm getting at is I want to get rid of this ambiguity or get rid of this concern, because I'm only tackling that first step. These are legitimate concerns that I think the government of the day and all of you as officials that would then ensure that the appropriate procedures and processes are put in place to protect this information after the fact. I just want to get to the point that parliamentarians, as Mr. Duncan laid out, as there's so many people that work in certain positions, and I would argue parliamentarians, with the threat environment that we face now, should be elevating our game when it comes to national security and intelligence and being better. And the only way to do that is actually to see a little bit behind the curtain. But the first step is to apply for security clearance. So I'm just looking for that assistance to reassure you, because I do not want to put, as somebody that's been in this world forever, any of our national security and intelligence assets at risk.
If I might, I think an observation you've heard from the panel of witnesses is that there may be an opportunity to clarify some of the vocabulary, and separating out the concept of applying for the security clearance from the concept of need to know might give an opportunity to clarify some of the language surrounding that.
Thank you very much, Mr. Ruff. Mr. Turnbull, 2.5 minutes.
Mr. Jorgensen, is the ambiguity that you were just referring to what Ms. Giles was just mentioning, which is that deemed need to know in the actual language of this bill, is that the ambiguity you were referring to, or was there another one?
In part, sir, I think we've raised a number of questions, for example, of does this standard, is what you're talking about, is it the public service standard? Because if it is, then that reduces the ambiguity quite a lot. So I think there's ambiguity about the safeguards and the ambiguity about the implementation afterwards.
You had mentioned before that members of Parliament who've been given access to information have had to take an oath. They've waived their immunity and privilege in other cases. Are you concerned that this bill gives them access to information but does not have them waive their privilege and immunity, i.e., certainly in my mind, increasing that onward exposure risk?
I think the parliamentary privilege is an important question for this committee to deliberate further on.
Okay, great. And then just to Mr. Duncan's points, he had mentioned that interns in Ontario desk staff at ministers' offices had secret clearance, but isn't that in virtue of the position that they hold?
So every time that you get a secret or a top secret clearance is because of the position you have and the responsibilities you have.
So they didn't decide to apply?
They did not.
And do they get access necessarily to any information? Are they deemed need to know on any information in virtue of having that secret clearance?
No.
Thank you.
Okay, colleagues, I want to thank our witnesses. This was a very good example of why the committee stage of the legislative process is so important. It allows us to delve into a variety of questions that members from all political parties have and to rely on the expertise of witnesses with knowledge and guidance that they can lend to the discussion. So for anybody that is watching, this is why we have the committee stage. Well, our adversaries need to know we've got a strong parliamentary system, that's for sure. But it's the teacher in me. Sorry, folks. Meeting adjourned. Thanks, colleagues.